Depending on the reason for the eviction, the tenant can be afforded different time periods for notices. For instance, if it's a non-payment of rent case, tenant simply has failed to pay rent, there is no notice required. You may immediately file a complaint, an eviction complaint, with the landlord-tenant court and evict the tenant forthwith. If the tenant has engaged in conduct that's in violation of the lease, you first have to send a notice to quit, and which advises the tenant that they're in violation of the lease, what provision of the lease they're in violation of, and the fact that if they continue to violate the lease, that they will receive a notice to quit and that they will be evicted from the property. If the tenant continues to violate the lease after having received a notice to cease, then the tenant is sent a notice to quit. Generally, the notice in a notice to quit is 30 days. After which time, if the tenant is still in the apartment or the premises, the landlord can then file an eviction complaint in the landlord-tenant court. There are certain instances that are not non-payment of rent where a landlord does not have to wait 30 days. There are certain instances where there is also a 60-day notice. But if there's destruction to the property, if the tenant has willfully or negligently recklessly or negligently damaged the landlord's property, he could possibly be given a 3-day notice to quit, and immediately thereafter, if he continues or she continues to remain in the premises, an eviction complaint can be promptly filed.